Honor, they did not have a judgment for possession. They had a judgment for a money,
Miss
and
Simmons, they
the
had a
plaintiff
judgment for
applied for a writ of.
possession.
She'd already agreed in court to pay her rent or be evicted, but instead she believes she found a legal maneuver to stop the landlord from kicking her out.
The case was previously resolved with the court via consent agreement.
Yes.
We did a consent back in October 30th. It was a pay and stay for Miss Simmons to pay past due rent and fees by November 5th. That payment was not made. Our client subsequently filed a writ of possession, application for a writ of possession. I don't have the exact date it was filed in front of me, but Miss Simmons informed us that she filed bankruptcy on November 13th, although I haven't been able to pull it on Pacer to confirm that date.
She filed twice. She filed 2 notices. I'm not sure what happened to the first one, but there was a second one that was filed more recently. I don't know if it's the same. Is it the same case, Miss Simmons, or did you file 2 separate ones?
Yes, it's the same case. I filed the second one to notify the court that there was a violation of stay because they filed the writ of possession on November the 17th, and I filed my bankruptcy on November the 13th.
Okay, but they had the order for. I mean, I don't know that it. So, what did you guys come to some sort of agreement on this? Or the reason I brought it on today was because she had submitted a letter regarding the funding, like there. And again, I know this. I just wanted to make 100% sure. I'm not sure which housing authority Columbia Residential is part of, or if it is necessarily part of it, but there was some sort of letter stating it was the same day as the consent agreement was issued, saying that there was a moratorium on evictions for the Atlanta Housing Authority, which I wasn't sure if Columbia Residential was funded by that or not. That was my question.
It was just PHA units. There was a brief moratorium before the federal shutdown was ended, but that moratorium is since expired. It expired when the federal government opened back up, and it was just for AHA subsidized units. My understanding is Ms. Simmons is not an AHA subsidized PHA or PBRA unit, so that wouldn't apply. Our position is we have a consent order for her to pay it on the 5th. The writ was essentially available after the 5th, notwithstanding whether it was applied for. There isn't a stay of the bankruptcy, but if the court has a different opinion on that,
it's my understanding from the bankruptcy law that the writ, because the order was entered prior to the bankruptcy being filed, that the writ is still valid. So I think they can go ahead and get the money judgment. They can't. I mean, they're going to have to hold off on collecting that, but that was also obtained prior to the bankruptcy. So I don't think it's. Hold on. I don't think it stays the writ based on the law. So Ms. Simmons, what would you like to say?
Your Honor, the consent order says the plaintiff may apply for writ of possession. The landlord did not have a judgment for possession, and the bankruptcy law states that they can only the stay does not apply only if they had possession. They did not apply for a writ of possession until November the 17th after I filed my bankruptcy, which the stay was immediately in place after I filed on November the 13th.
Okay, that's not what the law says. The law states that if they have an order granting them the writ of possession that is issued prior to you filing the bankruptcy, they were entitled to apply for a writ if you fail to make that payment, and that was already issued several weeks prior to you filing the bankruptcy. But the stay is still valid, in my opinion.
I'm to my understanding, I thought this was a hearing in regards to the application of the writ of possession that they submitted to the court on November the 17th, and they did not have writ of possession.
They did have the right, the order granting them the right to apply for that writ was entered on October 30th.
Correct.
By consent, mind you, by your consent, you consented to it and consented that writ would issue if you missed that payment, and that you missed the payment, and they are entitled to apply for the writ.
They're entitled to apply for the writ, but it does not say anywhere on here, and it's not checked off.
What are you looking
on
at?
here that a writ of, I'm looking at the consent order right now.
Okay, do you have any law to cite that, to support your argument that they're not entitled to the writ?
I have the law under that this bankruptcy, the possession after bankruptcy dated is prohibited under 11 USC 362. They did not
All right,
have.
I'm gonna just hold on one second. I'm gonna.
Mario. Mario, can you hear me?
Yes, I can hear you.
Hey, I just went online and went up under the CSS just to confirm something. We actually requested the rent or no
On the
writ on
7th.
November 7th.
Yeah, it was on the 7th. I see it now. Yeah, it
Okay.
wasn't the 17th. It was applied for on the 7th.
Right.
It may not have been signed by the judge to the 17th. So
Okay. I just wanted to let you know, I just went on the CSS just to confirm it. Okay,
it's clear.
I can hear you.
We're in open court, so I don't want to say too much about what we'll address it with the judge. But I just looked it up. It was applied for on the 7th before the bankruptcy filing. So we'll address it with the court.
Thank you.
All right, folks, I'm back. I'm here to cite the law I'm looking at, specifically 11 USC, Section 32B22 states the filing of a petition under the bankruptcy code does not operate as a stay, subject to subject 1 under subject A3 of the continuation of any eviction under unlawful detainer or similar proceeding by lessor against a debtor involving residential property in which the debtor resides as a tenant under a lease or rental agreement, and with respect to which the lessor has obtained before the date of the filing of the bankruptcy petition a judgment for possession of such property against the debtor. So again, in this case, the judgment was obtained prior to the bankruptcy filing, in which case that would not operate to stay the writ because the judgment was entered for the writ prior
Your
to.
Honor, they did not have a judgment for possession. They had a judgment for a money.
Ms. Simmons, they had a judgment for possession. Ms. Simmons, okay, I'm not going to argue with you about that any longer. I think this law clearly, they had a judgment that they would be entitled to the writ of possession. If you failed to make that payment, you failed to make the payment, they are entitled to possession. It was entered prior to you filing for the bankruptcy. I think the law clearly states that they're entitled to it.
Your Honor, for the record, I object to this proceeding because doing so violates 11 USC 3362. I need to preserve my rights in case any further action in the bankruptcy court becomes necessary. There is
all right, Ms. Simmons,
hearing with the bankruptcy court for this violation for January the 10th. So I respectfully request this objection be noted in the court.
All right. All right, Mr. Breedlove, do you have anything?
So no, Judge, that the writ. I'd also note, Judge, that the writ was applied for on November 7th before she filed bankruptcy. So that further supports our argument that the stay would not apply. So we asked the writ be enforced in Stater.
Okay, let me take a
I
look at this.
also, Your Honor, want to note for the court's record that being notarized, the affidavit may have been notarized on the 7th, but it was not filed into the court until November 17th, which was 4 days after my bankruptcy filing. Filing any document to move the eviction forward after bankruptcy is a violation of the automatic stay. Notarizing something is not a filing, submitting it to the court is.
Let's see here.
And I also would like to request a copy of this Zoom hearing.
Let's see here. What is the thing? In the case and reviewed the law regarding the issue and the matter, looking at the timing of everything, I do find that they are entitled to enforce their writ of possession. So I will go ahead and sign that today. That is the order of the court. So I will I'll do a brief order on that and get that done right after court today. So you are all free to log off. Thank you.
Thank you, Your Honor.
Judge.
If you're involved in a dispute with another party such as this and you just can't seem to work it out, don't resort to taking the law into your own hands. You take it to court.
All right, thank you very much. Officer Burrell's waiting for you, and that will bring this case to a conclusion.